5 seconds to go. Start. In view of the above, the High Court upheld the conviction of accused numbers 1 to 7, 9 to 12, 14, 16 to 19 under sections 143, 147, 148 IPC and 32E of PDPP Act read with section 149 of the IPC, and also the sentence of 4 years imprisonment imposed upon them by the Sessions Court. Therefore, the learned counsel for the appellants were justified in contending that the High Court has not considered the submissions of the appellants on law and on fact. The High Court, while exercising criminal appellate jurisdiction under Section 386 of the Code of Criminal Procedure 1973, has to necessarily access the evidence on record with a view to satisfy itself that the appreciation of evidence by the trial court is not vitiated by any illegality and is not palpably erroneous. The dismissal of appeal without considering an appellant's contention is a serious infirmity which will result in no legal judgment in the eye of law. Miss Sonia Mathur, learned senior advocate appearing for accused numbers 1 to 7, 9, 14, 16 and 18, at the very outset contended that the High Court has not rendered any independent finding on the issue of destruction of public property and has merely reiterated what the Sessions Court had held. Be that as it may, the central thrust of Miss Mathur's submission was on the manner in which the TIP was conducted. According to her, the TIP was of utmost importance considering that this was a case where criminal liability was fastened only against a few protesters. She raised questions over the integrity of the TIP by contending that the ideal ratio of suspects to non-suspects as laid down by the Kerala High Court in Pradeepan v. State of Kerala has not been followed. The presence of IO PW84 in the premises of Central Jail during both the TIPs vitiates the TIP in its entirety. The IOPW47 in both the TIPs did not record physical features, age, etc. of the known suspects. The learned senior counsel gave an example by stating that accused number 7 had a long beard, but there were no known suspects having a long beard. The IOPW84 has admitted that accused numbers 1 to 16 were in his custody when he questioned the eyewitnesses in his office. PW3 and PW4 have admitted that they had seen the accused while they were at the police station. PW1, PW8 to 12 and PW33 have admitted that they had identified the accused in the TIP based on the pictures they saw in the newspaper. The accused had complained that while they were in police custody, they were photographed and shown to the witnesses from the cabin of PW84. Remand report dated 14th July 2000 clearly stated that accused numbers 1 to 16 were shown to the eyewitnesses. There has been a delay in holding in the TIP, which is fatal in light of the decision in Lal Singh and others versus State of UP, and no importance can be given to the identification made in the TIP when the same witness fails to identify the same accused before the court. For this purpose, reliance was placed on the judgment of this court in Lalli alias Jagdeep Singh versus State of Rajasthan. Independent of her submissions on the aspect of TIP, the learned senior advocate also relied upon the decision of the Delhi High Court, where it was held that re-examination of witnesses should not be allowed, especially to facilitate them to rectify their mistakes. This submission was made in the context of PW3 and PW4's contradictory statements made in the chief examination and the re-examination. Shri Vinay Naware, learned senior advocate appearing for accused numbers 10 to 12, contended that the statements given by PW5, PW6, and PW8 could not form the basis of conviction because PW5 had stated in his deposition that he was not present at the time of the incident and that he reached the place of occurrence only after the incident. PW6 could only identify accused numbers 17 and 19 and could generally identify the other accused as the agitators. PW8 had stated in his deposition that he identified the accused on the basis of the images he saw in a newspaper. Shri Naware also raised questions over how the TIP was conducted by submitting that the purpose of conducting a TIP fails when pictures of the accused are published in newspapers. He relied upon the decision of this court in Ravi alias Ravi Chandran versus State, represented by Inspector of Police, where this court had held that no importance could be attached to a TIP where the photos of the alleged suspects were making rounds in newspapers and also when the witnesses had a chance to look at the accused while the accused were in police custody. Stop.